Thank you to everyone who is listening in to this very special coverage of the 17th CITU All India Conference, which is taking place this year in the city of Bangalore. The conference is taking place and it has raised the slogan this year of unifying class, intensifying struggles, and defeating the communal divisive forces, neoliberal policies, and imperial machinations. Today with us we have a very special guest. We have Comrade A.K. Padmanabhan. He is a veteran trade union leader. He served as a former president of the CITU and he is currently serving as the All India Vice President of the organization. Comrade A.K. Padmanabhan is also currently on the Central Board of Trustees of the Employees Provident Fund organization, and it is primarily with respect to this role of his that we will be speaking to Comrade today. Comrade, in November last year, the Supreme Court of India passed a judgment on the Employees Pension Scheme Amendment 2014, which made some judgments on the EPS-95 scheme. In this context, could you tell our listeners just give us an overview on what exactly is the EPS-95 and what has been the position of the trade union movement historically on the same since its inception?
See, EPS 1995 is something the government produced when the workers all over India have been demanding for a social security coverage of monthly pension after retirement. And it was not 1995, it was in the early 60s, it continued. By 1971, the government had formulated a family pension scheme. If a worker dies while in service, his family will get a small amount. But that was nowhere satisfactory, and the whole scheme was, if I can say, it was a dubious thing. And that is what happened. And the 1971 started, it had accumulated fund and nothing was happening, nobody was getting benefits, and the demand came that there should be a separate pension scheme for those who are not only for those who die in RS, but it should be for everybody who retires. And so in 1995, finally, yes, from 93 onwards the discussion started. And by 95 they were ready with a sort of a program. Actually, there was no proper consultation with all the trade unions. At that time, those who were in the Central Board of Trustees, they were being consulted. It was being projected as a solution for all the problems of the private sector workers who are demanding pension. And to be brief, it had its own weaknesses, failures. Even at that time, at least CITU felt that this is not going to serve the situation. It wanted many amendments because the workers have been demanding pension as a third benefit. And what was it meaning? Other than the gratuity that is available to the workers, other than the Provident Fund scheme which is in existence, there should be a separate Provident Fund, separate pension scheme. We were not demanding with relation to the Provident Fund. What we were demanding was pension as a third benefit. This should be there. But the government, what they did actually was take a portion of the Provident Fund, 8.33, from the employer contributes, employee contributes. Earlier it was 8.33, later it was 12%. That 12 from that 12%, 8.33. They will say that it is from the employers. Employer contribution, employee contribution comes into the account of the employee. It belongs to the employee. But one portion is taken, and the argument from the employer and also from the government was that it is taken from the employer's share and the employer's contribution to the pension fund, which was already my money. That money was taken away and it was given as something new and a pension fund related to that. And that was actually, because I don't want to go into the past, it was to the credit of CITU, I will say, at that time. Now every central trade union, before going into that I will agree, I will say that now all the central trade unions are in one platform in raising the issues related to EPFO, that I will come later. But at that time, we raised it. Comrade M.K. Pandey, who was secretary of CITU at that time, he published he wrote a pamphlet and CITU published it. We want a real pension scheme. That was what we said. And the whole method, it was moved in the parliament, how it was passed, how various political parties took different positions, those who gave amendment to the scheme, how they withdrew the amendment, and finally making it adopted in the parliament despite opposition from some MPs who were leaders of CITU. Especially I will remember Comrade Balanandan, who was president, and Comrade Jeevan Roy, who was secretary of CITU. Both of them were members of the Rajya Sabha. They moved amendment to paragraph specifically saying that there should be a separate scheme and all that happened. But finally what happened was, by 1995, actually there were so many petitions in the Supreme Court making this, at least don't make it compulsory. It was thrust upon the workers. It was made compulsory to everybody. And this was happening, and there were protests, and it came to the Supreme Court, and then governments added something so that it looks little better. They said we have a commutation scheme, we have an annual review, we have a return of capital in the case of death of an employee, like that. And by 1996, before the judgment, before the court started hearing it, they also added those who can contribute higher than what is required under the law for their full wages. If the employer and employee both contributes on a higher level, and they will be eligible for a higher pension. That was there. But many people were not aware of that. And so it was introduced, and lately they decided, after some time, they decided to just keep it under wraps. And that was the issue that was coming up in the courts later on. And so this issue, and then in the 2001, Supreme Court started hearing. And it is, now it will feel, oh, nowadays it is like that. Even at that time, after the hearing was completed, for the judgment to be delivered, it took 20 months. After 20 months, it was 2003 only, the judgment was given. Because the government argued, they published a advertisement that this is far more beneficial than the government employees pension scheme. I don't think they will be prepared to republish the advertisement or say that at least this advertisement was published. Such a thing happened. And so Supreme Court took all this as in great belief of what the government was claiming, and they put a stamp of approval on that. They said it is a beneficial scheme. And before that, actually CITU had given a call for a one-day strike all over the country in protest against it. CITU was alone in that.
Which year was this?
That was in 96.
Okay.
And so this, we were conducting campaign, and finally when the court did this. And what happened after that is, by 2008, the government strictly EPFO, without even calling a meeting of the CBT, they withdrew the commutation scheme, they withdrew the return of capital benefit, and annual review was not happening. All together from 1995 to till today, only 3-4 reviews have taken place. Now government says, no, there is nothing. Review is for some increasing percentage. And there is no indexation. And so that way this was happening, and this happened. And the issue that went to court, there is a very basic issue which is related to the largest number of the Provident Fund contributors, who are the lower level wage earners, like BD workers, like industrial workers, like that, who were not even getting the wage ceiling, 6,500 at that time, then it was 8,500. Now in 2014 onwards, it is 15,000. All these wage ceilings, below those wage ceilings, those who are getting the largest number of the contributors to the EPFO scheme, they were getting only minimum pension and ridiculously low, 100 rupees, like that. When there was commutation, there was a worker, Sati Devi, a BD worker, who was getting only 2 rupees.
2 rupees, yes.
and at that time, the Labour Minister, when it was continuous representation was that, increased the minimum pension. That pension increase, when that issue was taken to the minister, he said, oh, at that time money order was sent. For sending this 2 rupees to the worker, we are spending 20 rupees for money order. That was what the minister was telling. That was the situation. And then there were 2 demands. Actually, one is increase the, reorganize the pension scheme, increase the minimum pension, at least 2,000, that time, at least 1,000 rupees.
Right.
But it was not happening. And so the whole issue, as far as the majority of the Provident Fund subscribers who are members of EPS-95, was that there should be a considerable increase in the minimum pension under the scheme. This was what was required. And so that position, 2014 onwards, up to before 2014, the government was pressurized, and UPA2 government at that time, they finally decided to increase, and the file was moved. Decision was taken. Labour Minister announced that yes, we have decided, but unfortunately, that time Finance Ministry as usual intervened, and he did not sign the file. I will not say that Finance Minister alone, the government did not accept it, and it was kept pending. That is the issue still pending, because even now this 1,000 rupees minimum, when they say, more than at least by 50% of the pensioners are getting less than 1,000 rupees now. Because there are so many reasons. Those who have got commutation, those who did not have full service up to 58 years. If you are 2 years lesser, your 8% will go. That way, your minimum pension is still less than 1,000 rupees. And so this is the one major issue that has not been settled, and that is not before the courts also. So when you come about the November judgment in the Supreme Court, that is a separate issue, and which does not involve actually the majority of the pensioners. This is what I want to make it clear, because this was what we have been telling from 95, that pensions should be something which that family, first of all, if you are declaring it as a pension, now what is the situation? Old age pension is 2,000 rupees, 1,600. Kerala government now pays those who are getting EPS less than 1,000 rupees. They are giving that 1,600 rupees. So every old man or woman is getting, old person is getting. And so that is the situation as far as the majority of this. And if you ask me about what was November, see, it is not November. It started 3 years ago. In 2014, it was notified, because after it,
what exactly were the issues that came before the different courts? I mean, it came
see,
before the
that's what I'm trying to tell. See, I told you in 96, they added a thing, those who can contribute for the higher wages, along with the employer. They can get, if they file a consent before the EPFO, they can get higher pension according to your contribution. This was what was there as a clause. And they, as I told you, they kept it under the wraps. They did not publicize it. But some of the public, especially public sector and old private sector companies, they were paying full for the full wages, not with the ceiling. And so that higher amount was being paid. Right. And so many people were not aware that we are eligible for, even those who are contributing for their full wages were not aware that scheme does not exist now, because after some time they kept it under the wraps.
Right.
Actually, government decided but did not amend the rules.
Okay.
Only in 2014, when a section of workers in different units, in Himachal Tourism Corporation, then some others in Kerala, where Milma and other units, they were paying the full wages, and they raised the issue that we are eligible for it. At that time, EPFO said, no, that time limit is over. You did not apply before that cut-off date.
Correct.
Before that cut-off date, you did not apply and you are not eligible.
Correct.
And so we were not aware that there is a cut-off date. That was the thing. And that was taken to the court. And court said, how can there be a cut-off date for that? Kerala High Court, Himachal High Court, Rajasthan High Court, Delhi High Court, they gave judgments that this cut-off date is invalid. But government did not agree. They went to the court, Supreme Court. Supreme Court said what the High Courts have said is correct. Then a review petition was filed.
Okay.
And that review petition, actually, I am not a legal expert, but that is what the legal experts told her. Review petition will be with those who gave the judgment. It went to them. They said, no, because by that time the government created a situation that if this is agreed, EPFO will disappear, we will have no fund, no money, all these huge cry. Actually, it is not based on facts. That has been the position taken by the trade unions.
Right.
But they did that, and court decided it will go to a 3 judges bench. So 2 judges bench give a judgment, and then a review petition is filed. In that review petition, they decide to have a 3 judges bench, and the 3 judges bench heard that, and finally what was judgment given on 4th November was that it is a mixture. Actually, the basic issue, because from before 2014, the full payment system that is not continuing. Only those who were there. New people are not coming. Only those where the employer and employee have given joint consent and they have been deducting higher money, they are only eligible for this. It is not for all the members of the EPS-95. It was created. The feeling among many employees, those who are suffering for that, is the High Court and Supreme Court, they will give us something.
Right.
But it was meant for not for others, only for those who have been contributing for their full wages.
Full wages.
And now, Supreme Court has said different things for different people. And one major issue was, there are certain exempted units. Exempted units means the money is handled by, under the supervision of EPFO, a trust is formed at the factory level, that institution level, where employer-employee representatives will be there. They will be managing, and they will have to follow all the conditions that are stipulated by EPFO on interest rates, on other things, everything, investment, everything has to be under the control of or under the direction of the EPFO. But they said, no, that money is being kept there. Because those who are contributing for pension, it is in the EPFO office under the EPS, separate payment. The Provident Fund is a separate payment.
Right.
Like that. Then there is a EDLI, Employees Deposit Linked Insurance Scheme. Okay, that's not our issue now. And so this money, you are keeping it. You are not paid the full money. Only pension money, these exempted trusts were also paying to the EPFO. And the full money has not come. And so exempted units, you are not eligible. That was the position taken by EPFO. That the High Courts also, Supreme Court also said, no, there cannot be any differentiation. Now this judgment also says, 4th November, that yes, it is applicable to exempted units and also. And this is one major issue which are a section of the contributors who are in the exempted, under the exempted trust, they get it.
Right.
Actually, for others, it is still a confusion. Because that 4th November judgment, there are some specific grey areas. They say those who have not given the consent and retired before 1st September 2014, they are gone. You are out of it and you are not covered. And those who are retired before September 2014, but who has given consent and it was not taken up or it was rejected by the EPFO, they are eligible. And what will happen to those who were retired after 2014? Those who had given consent, they are eligible. But those who have not given consent, what will be the position? All these are grey areas. And after High Court judgment, to avoid the contempt case in the court, some payments have already been made. And at one point of time, they suddenly said, stop all that.
Okay.
Some workers are still getting it. And so these confusions have not been cleared. So 4th November judgment itself has certain grey areas. And now exactly on 29th December, because the court said the EPFO has to clear all this within 4 months. And for that, all the directions should be issued before 8 weeks. And so 29th December, if you calculate, from 4th November, exactly that date comes under the 8 weeks.
8 weeks.
And so to avoid somebody going to the court and saying that this EPFO has again not heeded to the Supreme Court judgment, what they have done is 29th November, they have actually issued a circular. And that circular itself is a highly confusing circular. Because now the news comes that yes, they are going to issue another circular where other points will be cleared.
Right.
Our lawyers are telling, others are telling that this issue also, there are very many grey areas and the judgment itself is problematic. But at least that judgment, the EPFO should come forward to say that yes, we will implement this judgment fully.
Right.
That they are not saying. That paragraph, this paragraph, all the confusion that bureaucratic systems can create, that is being created, and now the news is coming out in the papers. I am a member of CBT. When all this important judgment has come, CBT, Central Board of Trustees, have not met after the Supreme Court judgment. So what happens is, workers all over the country are expecting many things. But unfortunately, as it is, other than clearing some aspects of those who have already paid their money to the EPFO for higher wages with the consent of employers, they will get it. For others, they have also put a condition that all the necessary documents have to be submitted by the worker.
Yes.
If I am retired 4 years ago, 5 years ago, 6 years ago, where do I go for all the documents? Actually, all the documents which the EPFO wants are available in the EPFO office.
Right.
If they have not destroyed everything,
Yes.
they are not supposed to, because a pension system is going on. They have to keep all the documents.
Yes.
And so why they should ask the worker, poor worker, to keep all that? And so all these problems are there. That is why at least now the demand is, as far as the judgment part is concerned, implement the Supreme Court fully.
Okay.
That is one part. The first point, where the majority of the workers are involved, the point is, see, there have been, yes, after 2014, the order set minimum 1,000 rupees.
Right.
But that minimum 1,000 rupees has not come to more than 50% of the total pensioners. At least demand has been, the CBT at one point of time decided that at least 2,000 rupees minimum should be given, and for that the financial assistance should be given by the government of India.
Okay.
That was done. The Labour Minister declared it, and it was not accepted. And Maharashtra Governor now, Mr. Hoshiari, who was an MP at that time, he was a chairman of the Parliament's Petitions Committee, and that Petitions Committee suggested at least give 3,000 rupees.
Okay.
And there have been committees after committees. Hoshiari Committee, Parliamentary Committee, Standing Labour Committee, Standing Committee of Labour for the Parliament, and then High Empowered Committee. If you listen to all the names of the committees, they are all super committees, but all the recommendations have been kept in pending. And today I hear from the media that the government has said 2,000 rupees. The reply from Finance Minister to EPFO is, officially we have not been told, but I read it in some media, I don't know whether it is a fact, that government has said, Finance Ministry has said, there are different sections of people suffering, and we cannot be expected to be giving money to all of them. What sort of what is the history of this 2,000 rupees? What is that? Who is demanding this? Those who have contributed. See, any pension scheme, after the worker dies, yes, after the worker dies, there is a scheme for the spouse of the worker to get half the pension.
Right.
And after that, what happens? The whole money is forfeited. Even then, the EPFO says, no, we will crumble, there will be nothing. It is not, they produce actuarial reports. Actually, this has been happening from 95. Increase this wage, etc. In the court also, they said no, actuarial report says this will not be possible. This has been happening. And so whole EPS-95 system, the pension scheme itself, it needs a revamping. At least immediately, without even going into others, the minimum pension that is available should be, yes, for a minimum wages, Government of India accepts 18,000 rupees. Then the pension should be 9,000. At least what we are saying is at least give 3,000 rupees immediately so that it can further go. That 3,000 rupees also, even 2,000 rupees they are not refusing. 1,000 rupees notification which the government claims we have given minimum 1,000, it is not being implemented.
Just to pick off on something that you have just alluded to, you have given a very clear description of what the trade union understanding is regarding this issue. But you also mentioned that there were some grey areas with respect to the judgment. Could you just give us some clarity in terms of your concluding remarks on the issue? On what essentially is the position that the government and the EPFO has taken on the judgment itself?
On the judgment, I told you. See, the whole thing when the High Court judgment and the Supreme Court judgment came, it was not only EPFO which went to the court. EPFO went, and also the Government of India filed a separate petition. The parties to the case for review were by Government of India as well as EPFO. Now, officially, Government of India has not said anything on the judgment till today.
They have not said.
Though they have gone to court for the review,
Right.
Government of India has not said anything. Only thing that has come out, not a comment on the judgment or not an assurance on implementation of the judgment, nor not saying that we will again go to court, that also, that has not come from EPFO. Just to avoid a contempt case, they have issued that circular dated 29th December 2022.
Okay.
Even now, till today, as a CBT member, I have not heard a single sentence or not a word from the EPFO on this. This is the situation that is happening today, and what the government will do later, we can't say. Because there is every chance. Because finally I will tell you that where is the danger. The Supreme Court said, government has got every right to amend a scheme with retrospective effect or prospective effect. For that, legal steps have to be taken, not issue notification. And so if an amendment is moved and which can have retrospective effect also, that is valid, is what the Supreme Court has said. There lies a very serious danger, in my opinion.
Okay.
Not as a legal expert, I am telling as a trade union, with a trade union experience, that when this license is given, this direction is given from the court, they can, when the parliament meets, they can just bring a legal statutory amendment so that they can do anything. So we have to wait. And to avoid that contempt petition before they do that. And there are many other issues which are, if you have that for above those who are getting above 15,000 wages, that 1.16 which the government pays for the pension scheme, that the concerned worker has to give. That was the order by the EPFO. The government said, court said, no, differentiation is not correct. But for that to work out a scheme so that if EPFO does not suffer, they can take time to amend the schemes or find a way out.
Right.
And so all these things are clear signals that they have given liberty to the government to act.
Right.
And so now it is in the hands of the government to clarify, EPFO to give. The demand from the workers are clear. One basic demand is increase the minimum pension. The second is implement the order of the Supreme Court. Then implementation question comes, some gray areas that will also come and that has to be resolved. So that is what, as far as CITU as an organization is concerned, we are discussing that also.
Okay.
We want the organized workers and also the pensioners both together. Those who are working today are tomorrow's pensioners. And so the workers and the pensioners will have to join together to have a struggle. The social security system in this country needs not a revamp. Actually, it has to be invented or reinvented. We don't have they call social security code has come, draft is there. They say universal social security. But what is that universal security? I have not gone into a big story which is there from 2014 onwards for against EPF, against ESI. This government has been moving constantly and they were making very many efforts, and at every stage workers have responded, and the government has gone back, and that is the situation. That through the budget itself it had come, as if the social security schemes are bondage for the workers.
Right.
That is what our late finance minister 2014 said. And so all these are danger signals. From different parts, different areas, different angles, these threats are coming, and to save the social security system in this country, and to make it actually beneficial to the workers, we will have to struggle, and that is the only way out.
Thank you so much, Comrade, for taking out very valuable time in the midst of your busy schedule, for giving us a very comprehensive and sort of exhaustive understanding of the issue. Again, this is Nikhil Matthew speaking with Comrade A.K. Padmanabhan, veteran leader, from the venue of the 17th CITU All India Conference.
Thank you, all the viewers.